legal expert and attorney, criminal defense and civil law attorney, Adam Thompson. AdamThompsonLaw.com is the website. You can find out more about him. He's been practicing for over 20 years, and there's been two big Supreme Court decisions today that really do affect American life and really affect how we take in media in some cases and a little bit about our privacy. So he joins us now. Adam, how you doing?
Doing great. Nice to be back again.
Hey, thank you so much for coming on. I do appreciate it with the substitute host, but I love that you're coming on here. And I got to ask you, I'm going to start with the warrantless cell phone searches and some of the privacy laws here. The Supreme Court ruled Wednesday that police cannot go snooping through people's cell phones without a warrant in a unanimous decision that amounts to a pretty major statement in favor of privacy rights. Is that your reading of this?
Absolutely. I think this is a great decision. I mean, I've been touting this on the radio show that I host. I think it's just incredible that it came down this way, and I'm glad to see it. I mean, one of the big things we face in this, internet age where everything is just so full of technology these days. You walk around with cell phones, you walk around with iPads, laptops now. Anywhere you sit down could become a hot spot. You're sending text messages, you're sending emails, you're talking on the phone. And the fact that the government or law enforcement could listen in or intercept or read or save any of these type of files or communications was just alarming to me, because people need to take very seriously their right to privacy and also the right to be free from illegal and improper searches and seizures, which we're protected through the Fourth Amendment. And with the government just being able to do these things without any need to go to a judge, go to a court, get a warrant to get it done, and basically just listening on their own, decision, was alarming to me. Now what this decision does is says, hey, guess what? You want to go into these type of communications, they're going to be under the same scrutiny as when you want to conduct an arrest of somebody and you have to apply for a warrant. So basically now they have to have articulable facts or reasons that they could proffer to a court to say, here's why we need to listen to these communications or read these particular emails or whatever it may be. Now they have to go through more formal steps and the standard's been raised. And I think this is a great day for everybody's privacy rights.
Absolutely. And, when you're looking at this, you realize, and the Chief Justice actually put it this way, he said cell phones are different from regular phones, which, by the way, you need a warrant to tap into. You need a warrant in order to get those phone logs. And he says they're different in this way because people can carry around so much data, the equivalent of millions of pages of documents that police would have immediate access to without a warrant. But that data itself is qualitatively different than what someone might otherwise carry. So basically, you have somebody's entire personal history, medical records, whatever it might be. You get somebody's cell phone, you're essentially seeing into their soul. So the justices of the Supreme Court said we're protecting this.
Nail on the head, because think about just your basic cell phone. If you're like the normal person, you get it, you're excited. Oh wow, I'm in the 21st century. This is so great. You don't download every contact that you know. You go to numerous social sites, Twitter, Facebook. You're downloading information there and bringing in contact there. You may have some kind of cloud set up where you're putting all your office notes and materials. Look, I'm a lawyer. I have all my different client files saved in one way or another on my phone with all different legal documents or samples. If a police officer was to get that, they would have access to all different clients' files potentially, every contact that I have, whether it's business, personal, or relating to my firm. I mean, that's a huge ton of information. It's a personal computer in your pocket. And it's bad enough they've been listening into the calls and they've been reviewing emails and reviewing text messages, but just that aspect of what you can save and store on it with a memory card or within the device's hard drive itself, it's just amazing. Like you said, it could be in the thousands to even the million megabytes of pages and material. That is very scary.
And Adam, this doesn't apply to the NSA, obviously. The NSA is still snooping on us, right?
Well, listen, regardless of, and I live in the real world, okay? I'm not a fan of Republicans or Democrats. I saw you lead into this when you're talking about the IRS. You hope that the Republicans give it back to the Democrats. That's why Washington isn't working, because one side does it, the other side gets them back. It's perpetual, never ends. And this is why, it doesn't matter who's in office. We're still going to see this. Even if the Supreme Court says stop snooping, get warrants, do this, do that, do you really think think, regardless of who's sitting in the White House, Democrat, Republican, that they're really going to listen. The NSA is going to do what they want. Had you really pleased them? It went on for decades and decades. Snowden blew the whistle on that. No one knew or no one spoke out. It's still going to happen because how do you really find out at the highest levels of security who's doing what? What do we really know as citizens? You know, that's the whole point.
That's very true. We're kept in the dark. Hey, Adam, I want to get to one other case before we run out of time here, my friend. I want to talk about the Ario case because this is fascinating. This is a company that basically said, we're going to allow you to cut the cord with cable because you're going to be able to get the broadcast television networks that so many people are looking for, say, the Super Bowl or other live sports. Ario would set up little tiny antennas, and they've done it in about 10 markets or so, that basically are able to be transmitted to, over the air, because this is free, quote unquote, free over the air television. And it allows computers and other devices to receive those TV networks through these small little dishes. It's a brilliant idea. However, the Supreme Court said, and the broadcast TV companies won big on this one. They said, sorry, you can't do it. It's illegal. It's stealing the programming. What do you think about this? Obviously, it's it's a matter of content and rights.
You want to protect that intellectual property that you have. And, think about all these major broadcasting networks out there. I'm all for get the information out there everywhere you can, make it as cheap or free, because information's power. People should get that stuff. But, if you're a broadcast company, a network, or even a cable company, or any of these, whether it's Comcast, Dish, these people that promote it out there, you don't want to compete with someone giving away for free when you're making $100 to $200 a person that signs up for you. So basically, it's like, why are they going to be able to intercept to use the same materials we're charging for and broadcast it free? So basically, they had strong lawyers and a very good lobby to push this through because, on the flip side, it was a bad day for the government with those rulings and a good day for privacy. This is a big day for broadcasters and people that distribute all those broadcasts because now basically they got a bigger chokehold on the monopoly they already have to get the materials, put it out there, and charge for it. Because now, with this decision, first of all, that company that invested all that time and money into all that to put that platform out there, that's basically done now. So I would be afraid if I was an investor with stock in that company, because sort of plummet and it's going to go south real fast. But as a side note, other companies that want to get into that now have this as a roadblock, because if you try to get this intellectual property, these materials, and put them out there, you got this now as a stumbling block to get past, because all the companies will now be signing to this decision as a reason why you shouldn't and you can't.
So I still have to, bottom line, I still have to pay hundreds of dollars for Dish, other satellite TV, or some kind of cable access, right? I mean, if I want these channels, unless I get my own receiver, which doesn't always work, unless I get my own digital TV receiver, I'm still going to have to pay for these, this massive cable bill. This to me, I agree with Ario in saying that this is a big loss for the consumer. It loses the competitiveness, but at the same time, if these companies aren't getting paid, they're not going to produce the content anymore. So there is two sides to it, but bottom line is I still have to pay my cable bill, right?
That's basically it, because listen, you can get Netflix. There's so many companies out there that offer ways of getting streaming movies, streaming content. Now they're developing new programming. I mean, it was just the major networks. Just how many, 10, 15, max 20 years ago? 4 or 5 major networks, and Fox got in. And next thing you know, there's a million different cable stations that are all competing and now making new content, not just playing syndicated broadcasts. So these people want to promote their brand, their company, and build it up. So they're very afraid of companies like this with innovative ideas that are going to come along and say, hey, guess what? We can do it. We can do it for better, and we can do it cheap or free. That's very enticing to the consumer. So, bad for the consumer because you're definitely taking away the opportunity to get another version of a product you may like at a better deal, but it's not going to happen yet. Maybe down the line, but not yet.
All right, Adam Thompson, thank you so much. AdamThompsonLaw.com. We'll talk to you again soon, my friend. He's a legal expert attorney and criminal and civil law attorney. Again, AdamThompsonLaw.com. I'm Paul Westcott, filling in here on America Now with Andy Dean. We've gotten things rolling. Your calls and more, 877-927-ANDY. Coming up next.